other very, very, very quick matters.
Excuse me, Your Honor. Am I in the right courtroom?
Tell me
My
what.
name is Jessica Palmer.
Okay. Ms. Palmer, are you anticipated to be involved in a family law matter today?
Yeah, I have a free trial at 9 a.m. for my divorce.
Yep, you are in the right place.
Awesome, thank you.
Great, you bet. We're on today for presentation. There's Ms. Gilmore, she's present. And let's see if Ms. Winkles, are you on the line?
Yes, there we go.
There. Okay, great. All right. Thanks for the proposed orders and thanks for the objections. Ms. Height is here also. And so it looks like there was no opposition to the order on adequate cause to change a parenting custody order. Is that correct?
That's correct.
Great. And Ms. Height, are you comfortable with that one? I think you said yes. That's what your lips said.
Yes, I muted it. Yes, I agree.
Okay, great. And then the other order that seems to be fine with all parties is the order appointing guardian ad litem. Any concerns with that order?
No concerns.
Okay, great. I'll sign off on that. And then the concerns were expressed on the order on hearing from November 7th, 2003 is the title. And let's take a look at those. Paragraph number 4, which is starts off petitioners prohibited from consuming alcohol, and then stricken 12 hours prior to or during the residential time of the child. I think what I'm going to do on that.
And just so you're aware, Your Honor said that that Mrs. could request the test the day before or the day after visitation, and that covers essentially, if we're looking at the hair follicle, or sorry, not the hair follicle, if we're looking at a UA, it covers pretty much everything. But I think Your Honor said Tuesday, but it was iffy on Tuesday, so it was essentially a ban on alcohol, which is great. But the way Your Honor stated it was no drinking on visitation, and the alcohol test can occur the day before and the day after.
Great. Thanks, Ms. Gilmore.
I had it on my notes that there was some sort of prohibition prior to. I mean, if he's drinking up to visitation, then he'd be drunk at visitation. So typically there's some sort of buffer period of 8 to 12 hours. Again, I'll defer to the court of whatever your intention was.
Thanks. Ms. Height, any comments?
I think having a buffer is a good idea.
So in paragraph 4, it'll read petitioners prohibited from consuming alcohol 8 hours prior to or during residential time with the child. Then
and my client's in treatment, so it doesn't matter either way, really.
Okay. All right. Then on paragraph 6, it reads, respondent may request a urinalysis, hair follicle, drug screen with ETG the day before visitation or 24 hours after visitation. I'm going to strike the or hair follicle and leave the drug screen with ETG and the UA, basically. And leave also the day before visitation and up to 24 hours afterwards. So I'm going to leave that as is. And then at the bottom part of that on line 9 through 11, it reads, if positive, the testing party shall reimburse the costs of testing to the requesting party. And it says within 10 days, then that's requested to be stricken. A positive test will result in suspension of petitioner's visitation until the next hearing. I'll hear from you.
And actually, I'm fine with that now that we got rid of the hair follicle. The hair follicle is notorious for testing essentially false positives due to, shampoos and things like that. So it's absolutely fine now the way it is with if we're just using the urinalysis.
Okay. All right. Great. So we'll just keep that. And I think that takes care of all the concerns that were raised in the objections. 08.
I believe so.
And,
Thank you.
Stuff is here and Mr. Swenson is here. Welcome each. We're on today for Ms. Morris-Teff's motion for repayment of funds. So I'll turn the time to Ms. Morris-Teff.
Yes, Your Honor. This has been going on since April 14th, and Michael's been prolonging this. However, he's already got the spousal support vacated, but not only, I think 2 judges already had agreed for him to repay the refund payment of the stolen money, and I'm ready just to get this done and over with. I've tried to call and work with him to set up payments, and he still wants to ignore me and just not care. So I just want to get this motion started to where he just needs to get it paid in 30 days or go to jail, because he's not wanting to work with me at all or make payments whatsoever.
Okay. And in particular, just so I'm making sure I'm understanding this more stuff, you're talking about the $3,113 that basically the tax monies, right?
Correct. Yeah.
All right, thank you. Mr. Swenson?
Thank you, Your Honor. For the record, Stephen Swenson for the respondent, Michael Renee Teft. This motion is basically asking for another order. As Your Honor is aware, you left the judgment for $3,113 valid in the divorce decree. So there's already an order for him to pay within 30 days. Last week, Commissioner Carmi held the respondent in contempt for not paying that order. So there's already an order in place ordering him to pay the money. So I would state for the record that this would just be another order stating the same thing, and would be duplicative and kind of pointless at this point.
Mr.
Well,
Swenson?
if I may, sorry.
No, it's okay. We'll get to your question and comment. Mr. Swenson, yesterday you mentioned that Commissioner Carmi made a finding related to the non-payment. Is that correct?
Correct. Last week on the 15th.
Okay, last week.
And I think it just came up on Odyssey yesterday.
Okay. And the specific, was it a written order or was it just the notes?
It was written order.
Written order. Okay. Let me just take a quick look at that because that may inform my next question, and then I'll definitely hear from you, Ms. Morristow. Okay, so yeah, I did see that. Then
She wanted us to work together to set up a payment plan, and I've tried to reach out to Michael plenty of times, but he wants to ignore me. He told his brother to tell me that I wasn't getting shit, excuse my language, but that's what his brother came and told me. And I've sent him text messages as well. And so I just don't see us being able to work a payment out because he wants to be stubborn.
Ms. Morris Simmons, can you email me? I've discussed a payment plan with my clients. If you could email me about that.
okay, so it looks like there's a purge provision within that order that Commissioner Carmi provided last week. It says that the contempt can be purged if he makes a payment towards the repayment that's past due, and also make a payment plan to pay the rest of the repayment money that's past due, or proof he paid it back previously. And then it would be reviewed, looks like sometime in December. All right. Correct. So Ms. Morristow, I had asked a question. You were going to ask a question or make a statement. So I'll turn the time to you.
Oh, I was just saying, after that, I did reach out before his attorney just said that he had a payment plan. I've reached out to Michael. I felt like he chose not to respond. His attorney had plenty of options to email me or contact me and I'm just now hearing about this little proposal payment plan. So I just feel like, and this has been ongoing forever, like I feel like this just needs to be paid and be done.
Okay, thanks.
Just quick rebuttal. The Carmi's order was entered on the 15th, and so it's been less than a week.
But this has been going on since the divorce started, since the decree got signed on the 14th of April.
Right.
And the repayment was in the decree.
Yes, you're both correct. You're both correct. Yeah, the order was in the April 2023 order. It was also reaffirmed in the most recent motion. And then there was the contempt order filed on the 15th that Mr. Teft can purge that finding of contempt if he makes payments, and then also establishes a repayment plan. So here's the tricky part with orders. A judge can order that somebody do X, Y, or Z, and if they don't, then they can be held in contempt. Or the other thing that can happen, if it's a money issue and a person hasn't paid it, then the person can bring that to the court's attention. The court can reduce it to a judgment, and then a party can go after that judgment and try to collect on it. And that can be troublesome and difficult. Also, the court can set up a purge condition, which will allow a person to make a payment on it, which has been done here. And so at this point, there's the motion for repayment of funds. I think it's already in play, the repayment plan. So I'm going to let that play out, and I'm going to deny the motion for the repayment of funds. It's already been ordered. He's required to pay it. It's accruing interest at 12%. And that sounds like there's work. So something's in works as far as the repayment plan. So at this point, I'll deny the motion. I recognize it's probably frustrating to Ms. Morristow, but I think that's what I need to do. So I'll deny that motion. So that'll complete the matter for today. I'm assuming that Ms. Palmer is here because she chimed in earlier. Ms. Palmer, are you still here?
Yes, I am.
Okay, welcome to you. Ms. Looney is present from the state. Welcome to you. And Ms. Hyde also, Guardian Ladim is present. Welcome. And then I'll ask if Mr. Jason Palmer is on the line. Jason Palmer, if you're here, please let me know. Okay, not hearing a response. So Mr. Palmer, if you are here, I can't hear you. So please make sure you're unmuted and state your name. It looks like somebody's just seeking to be admitted. So let me double check if that's him. All right, is Jason Palmer
Here, I had a brief text exchange with Mr. Palmer yesterday. I know that he is aware of this hearing and was preparing for it. So
okay?
I'm surprised that he's not here.
Thank you, Ms. Hyde. Jason Palmer, if you're here, please state your name.
I am here, sir.
Okay, welcome to you, Mr. Palmer. On the line with us, we have Ms. Looney, representative from the state, and Ms. Height is also here, and Ms. Jessica Palmer is present. So we're here today, excuse me, we're here today for a pretrial hearing in preparation for a trial that's set for the week of December 11th. And there'll be a readiness hearing December 5th to nail down the specific date and time that the trial starts. So we're here for a pretrial, and let me just touch base with Ms. Looney if you have any requests related to the pretrial and preparation for the trial.
No, Your Honor, the state's ready to proceed to trial.
Okay, great, thank you. Ms. Hype, do you have any particular requests?
Apologies, Your Honor, for the delay. No, Your Honor, I do not.
Okay, all right, thank you. So let me just make mention to Mr. Palmer and Ms. Palmer related to pretrial. So some of the things that we generally talk about pretrial is a time to make sure that everything's going in the right direction in preparation for the trial, meaning there's been disclosure of witnesses, that there's been disclosure of evidence or documents or other tangible things. So just want to first talk about that. So let me just start with Ms. Palmer. Do you have individuals that you plan to call as witnesses during the trial?
No.
Okay, so do you plan just for yourself to testify?
Yes.
Okay, great. And then, Mr. Palmer, do you have plans on calling other people besides yourself to testify?
No, sir.
Okay, so you're just planning on just yourself, is that correct?
That is correct.
Okay, so please be aware for both of you that if you know we come to trial and all of a sudden at the last minute say, hey, I want this person to testify, that could result in a continuance of the trial. It doesn't have to, but it could. The judicial officer could make a decision that was a big enough a surprise because there wasn't a pre-disclosure or disclosure prior to the trial. So that may be grounds for continuance. So just keep that in mind. And if at a future date here in the next little while, you feel like that there may be other people that you want to call, that would be important that you notify all parties involved by submitting a witness list to the court and also transferring that to the other party. So let me I think the issues to be decided at the trial are the following. One is the parenting plan. Two is child support. Three would be property and debt distribution and any restraining orders. So let me just touch base with Ms. Palmer. Ms. Palmer, from your point of view, are there any issues related to property and debt distribution?
Yeah, there actually should be, because while we were married, he used my tax return to spend $4,000 on wheels and tires for his truck that I never approved of. I'd like to know how he plans on paying that back since he did not have a job at that time. That's not the only debt that we had incurred together. I had a $2,000 loan against my paycheck for a new fridge for the motorhome that we lived in. And shortly after getting the loan against my paycheck, I ended up having a restraining order against him for a year. So I solely paid off that fridge that I couldn't even get within 100 feet of. He said at the time that he would make a payment plan to pay me back for the fridge, but that was 2 years ago and nothing has been said or done about that.
Okay.
But I spent $300 a paycheck to pay it off until January of 2021.
Okay, thanks. All right, and then from your view, Mr. Palmer, do you feel that there's property and debt distribution issues that need to be addressed?
I'm not really sure how to answer that. I mean, I don't really want anything from her, but she's contesting that I owe this money that was money given to both of us, not just her. And her and I did discuss every penny that I spent. So that I don't know what else to say about that. I'm sorry.
No, that's fine. We're not going to resolve the dispute today. That'll be done at trial, but I just want to get a preview. And then parenting plan is at issue, and then child support. So as far as information that you might consider for the parenting plan, you might want to consider any evidence that you'd like to share related to any parenting concerns, any issues related to exchanges, any prohibitions or concerns related to substances or people or discipline, communication styles and the necessity of the Family Wizard app, whether there's cleanliness issues, counseling issues, clothing issues, parenting classes, things of that nature. Also be aware with child support, you should be prepared with pay stubs or some type of information that relates to your incomes for gross and net, and also possibly tax records. That's something that you might want to have available. That makes it much more readily understandable about what your positions are. So any questions about that?
No, Your Honor.
Okay.
Not at this time.
And then I just want to make mention of one item. I'm making an assumption, and I could be wrong, is that I'm assuming Mr. Palmer and Ms. Palmer, this will be the first time that you're involved in a trial representing yourself. Is that accurate?
Yes,
Your Honor.
Okay. So I just want to give you just a general overview what's going to happen on that day. You'll come to court, or you'll be involved, or it'll be via Zoom, one of the two. And then each of you, as we begin the day, I'll ask or the judge will ask if there's any preliminary issues or any issues related to the trial that need to be sorted out before the trial starts. So if you have something to address, you can address it at that time. After that, you'll each be given time to give an opening statement. An opening statement is basically kind of a preview of your case. It's what you anticipate the evidence will show during the trial. So you'll each have an opportunity to share an opening statement. It's not a time to argue the case. It's just an opportunity to kind of lay out the evidence as you see it and the relief that you're asking for. After you've given an opening statement, then the petitioner goes first. So that's Mr. Palmer. Mr. Palmer, then you would call your witness or your witnesses, including yourself, and you'd share all the information related to the parenting plan, related to child support, if the property debt distribution issue, and any other issue that you think is worthy of to be addressed. After you've finished your testimony, then Ms. Palmer can ask you questions. We call that cross-examination, and she can address anything related to the issues that are being discussed at the trial. After she's asked you questions, then you can address any issues that she's raised that need additional clarification, at least in your mind. And then after you've shared that information, then Ms. Palmer can ask you some additional questions about that line of questioning or those topics that were raised on the cross-examination. So then once Mr. Palmer's finished testifying and Ms. Palmer's asked him questions, then Mr. Palmer could call additional witnesses. I know you both said that there's no other witnesses. And then if there are no other witnesses for Mr. Palmer, then the time would be turned over to Ms. Palmer. Ms. Palmer, then you would go forward and share your testimony related to the parenting plan, child support, any property or debt distribution, anything that's relevant to the issues to be decided. After you've shared your testimony, then we would turn the time to Mr. Palmer, where he could ask questions of Ms. Palmer related to any of those topics. And then once he's finished asking those questions and Ms. Palmer answering them, then Ms. Palmer would have additional time to maybe to rebut any issues that were brought up by Mr. Palmer and share that information via testimony. And then Mr. Palmer would have additional opportunity thereafter to provide additional questions or ask questions of Ms. Palmer. And then Ms. Palmer, at that point, if you have additional witnesses, you could certainly call them, or you can call them in any order that you'd like. And then at that point, Mr. Palmer would have an opportunity to call any rebuttal witnesses. It sounds like that may not happen because you don't have any additional witnesses, but he may testify a little bit more, and then Ms. Palmer would be given the same opportunity. So at that point, that's all the information that the court has. And so it's in your testimony that you lay out the specific evidence that supports your position. And that includes, any documentary proof. And so if you do have documents, you'll need to make sure that the other side has copies of those documents prior to the trial. For example, if you have a pay stub that you want to use during the trial, you'd have to provide a copy of that prior to the trial to the other party. So start thinking about that to make sure you have any documents that you want to have available, shared with the other party prior to the trial. And that includes Ms. Looney and Ms. Height. So that's just kind of an overview. And then once you've provided all of your testimony, then we go to closing arguments. Closing arguments is basically where you take the evidence that's been presented during the trial, and then you argue your case. Be aware that oftentimes people will be representing themselves, and it's kind of a tough thing to do. And then they forgot that they didn't testify of something during the trial. So that prevents them from using that bit of information in their closing argument. So any evidence that you, or any argument you want to make, there has to be a basis or a foundation or support in some factual basis. So if you want to argue it, then there needs to be a basis in your testimony or in the testimony of the other party. So you'll both make your arguments of why you feel the respective things that you want or relief that you want is proper. And then once you've given your arguments, then the judicial officer will either take it under advisement and then issue you a ruling later on. It could come in letter form, it could come in verbal form, or the judge may decide to go ahead and give you a decision right there on the spot, verbally. So after that, then there would be orders that would be prepared that summarizes the judge's ruling for the parenting plan, the child support, and the like. And that would likely be held at a different time after the judge has given the oral ruling, and then those orders could be prepared, and then we would set it over for what we call a presentation date. And the presentation date would be everybody have a proposed order that have been prepared, and you can each prepare your orders, and you can object to the other party's orders, and then the judge would make a decision and sign off on one of those orders or amend that order that's been presented. So that's just kind of a long-winded overview of the trial. So I'd encourage each of you to prepare with the specific evidence that you want to share that you feel is relevant, and make sure you have a list so you don't forget anything. And so you can just lay it all out on the table and be ready to go. So with that said, I'll just ask the parties if you have any questions. Mr. Palmer, any questions?
Not at this time, sir.
Okay. Ms. Palmer, do you have any questions?
No, Your Honor.
Okay. Ms. Looney, Ms. Height, any additional items?
I do. It sounds as if you are expecting that I would attend that trial. I'm not being called as a witness. So what is your expectation on that, Your Honor?
Well, if you, let me just ask the parties. Ms. Palmer, Mr. Palmer, do you plan to have Ms. Height testify at the trial?
Yes, sir.
So was that a yes? You do plan to call Ms. Height, Mr. Palmer?
Yes, sir.
Okay. All right. So Ms. Height,
That answers my question. My further question is, this was a county pay case.
Mm-hmm.
Would you authorize me to bill the county for my time on that trial date?
Yes.
Thank you.
Yes. Okay. Ms. Looney, any final questions or comments?
No, Your Honor.
Okay. All right. If there's no other issues, then we will see the parties on December 5th at 11:30 via Zoom. That'll be the readiness hearing. That's when we'll find out the specific date during the week of the 11th when the trial will start. We're planning on a half day, and it usually starts in the morning. So if there's no other questions, Ms. Gilmore represents Ms. Is it Vasquez?
Friend.
Vasquez. Okay, Ms. Vasquez. And
Sorry, Your Honor, friend. Her name's Juanita Friend.
Friend. Okay, great. Thank you. All right. So Ms. Friend is on the line today, I see. And then
Yes, I am.
And okay, great. And then is Kyle Lopez on the line this morning? Kyle Lopez?
Yes, Your Honor, I'm here.
Okay, welcome to you, Mr. Lopez. We are here today on Mr. Lopez's motion for contempt related to son's bank account, a visitation on the weekend of the 8th and through the 10th of September, and decision-making regarding preschool. So I've read over the parties' pleadings. So Mr. Lopez, if you want to go forward and just go ahead and argue your points, and I'll hear from you, then I'll hear from Ms. Gilmore.
So this has been going on for 3 years now. I'm here representing myself because this is an easy matter. Um, I in our parenting plan, there's three main things that I'm here for today. One of them is the bank account situation. In our parenting plan, it states that I'm supposed to be on all decision making and have access to all information, and I simply don't. My son's tribal, and I'm not even able to call his tribe and get resources and help for him. Juanita has called the tribe and told them specifically to not let me call or receive any type of information regarding my son.
I apologize for interrupting, but I do have to object. I don't believe that was contained with the materials, and I don't think that's actually accurate.
So let me ask Mr. Lopez, the three items that I at least I saw in your motion for contempt was one that you didn't have access to the son's bank account, that you're asking for contempt on the missed visitation, and that three decision making regarding preschool. So those are the three basics
Yeah.
I'm looking at. Is that accurate?
Yes.
Okay. And then if you could help me on the access to your son's bank account in the parenting plan that was signed on December 15th, 2022, can you show me where it relates or addresses the bank account information?
I'm trying to find our parenting plan.
Yeah, I found
Sorry, what's that?
I found one provision that reads, it says, access to information regarding the child's GWE payments. It says mother shall sign any documentation necessary to add the father as a person who has access information regarding Cowlitz Indian tribal benefits and daycare benefits, healthcare, and GWE payments on behalf of the child. The parties agree that the GWE shall continue to be directly deposited into the child's Red Canoe savings account 5465. So that's the one provision that I saw that seemed to relate to the bank account. So is that the provision that
Yeah.
you're relying upon?
Yeah, I'm supposed to have access to that bank account, and I attached an email or a attachment, Exhibit A, where it simply says that I don't have any access. Like, I don't have any reason to pull out money or mess with it because I have reason to believe that it's not able to be pulled out from or withdrawn, only deposit into that account, as that's my son's money. And I can't even call to request information if he had gotten a GWE or if that money is still there or anything regarding the GWE or his money in his savings.
Thank you. Can I ask you, you said there's an Exhibit A attached to your motion, is that correct?
Yes, it's the Red Canoe email. It says Kyle Lopez has no access to any accounts with Mauricio Friend Lopez.
So I'm looking at your motion for order to show cause that was filed on October 4th. That's the document that says that has Exhibit A attached?
Yes.
So on my motion, the motion that's filed with the court, there's 5 pages and there's no Exhibit A. So it's just all the motion itself, motion for contempt hearing. So there's no Exhibit A attached to it. Might it be on a different document?
No, it should be in that same document.
And I can kind of chime in.
Ms. Gilmore, you were saying?
Sorry, I was going to chime in. I also was similarly confused. I received some materials via email. It was like testimony in the body of the email. I didn't actually review it until yesterday evening when I was preparing for today. So I didn't see anything in Odyssey either. So I don't think any of his responsive materials actually got filed with the court. But I don't know. I wasn't sure what he actually did.
Yeah, I have 3 attachments that I attached to it.
Okay. And were those attachments that Ms. Gilmore said she received some information yesterday or before, and that she was looking over that? Is that the information you're talking about? Because it sounds like you're
yes. So the 3.
Sorry, it's the Zoom delay thing. Go ahead and finish, Mr. Lopez.
I have 3 attachments to it. One's for the visitation and her not meeting me halfway with my work schedule, and then the second one is the police report of when the officer had to call them and ask what was going on for not coming to pick up and what the reason for was. And then the third one was the bank account email.
Okay, and those three documents, did you submit those to the court and when?
I was told to give it to her attorney.
Okay, all right, so you gave it to the attorney, but you didn't file it with the court, correct?
Correct.
Okay, so that puts me at somewhat of a disadvantage in that both you and Ms. Gilmore have seen the documents. I haven't seen the documents. I'm assuming that it's something that you would like me to see those documents, and so if that's the case, then I think we should probably, I would entertain a motion to continue the matter so that I can review those documents and we can all be on the same page.
Yes, Your Honor, I'm fine with that.
Okay. So what that means, Mr. Lopez, those documents that you gave to Ms. Gilmore, you'd need to file those with the court also, and that would probably mean we'd need to set this over probably 2 weeks because Ms. Gilmore's client would have an opportunity to reply to what you had filed. Yeah, Mr. Lopez, what do you think about that? Rather than maybe going into January, if you can get those documents filed with the court today or tomorrow and just send a copy to Ms. Gilmore, would you be able to do that, do you think? Looks like the mute's on. Now it's off. Now it's on. Now it's off.
Yes, and would I still have to send it as well?
Oh, it's a little.
Would I still send it to the court as well, or?
Definitely get it to the court, and then if it's the same document, the best course to do is to file with the court and then send a copy of the exact documents to Ms. Gilmore, just to make sure there's no confusion.
Oh, all right.
So if you're able to do that, would you be able to do that today or tomorrow?
Yes.
That would be perfect. If you can do that, then we could have the hearing on the 28th of November. And if that's
Okay.
agreeable to you, the 28th, that sounds like it's good for Ms. Gilmore. Would the 28th work for you, Mr. Lopez?
Yes.
Okay, great. So get those three documents that you'd mentioned, get those to the court, file those with the court, and send a copy to Ms. Gilmore. And then we will set this over to the 28th of November at 9 a.m. and we have Mr. Foley representing Mr. Torres. Mr. Foley's present. I can see him. Yes. And Ms. Wolski, are you on the line?
Yes, Your Honor.
Okay, there you are. I see you. Welcome to both of you. Good morning, Your Honor. Good morning. We're on today for the motion brought by Mr. Torres, represented by Mr. Foley, sorry. And I saw proposed orders filed by both Mr. Foley and also by Ms. Wolski. And so if there's any preliminary issues, we can hear those. Otherwise, I'll hear from Mr. Foley.
Thank you, Your Honor. I think my client pretty much laid out his position in his declaration. This was a 4-year relationship resulting in the birth of one child, Mason, who is 2 years old. My client, as indicated in his materials, worked from home and continues to work remotely. He's currently holding down 2 jobs, one with the state of Washington, where he is a senior systems administrator. He's actually the acting supervisor, and then a second job at a company called SSI, where his title is senior Microsoft systems engineer. That second job, as the court can see, the parties had significant financial issues, and so the second job is primarily to pay down debt. So
can I ask a question related to that, Mr. Foley?
Sure.
I saw pay stubs from L&I. Did I receive any information related to the SSI?
No, Your Honor. And actually, I did not learn about the second job until actually this morning. So I'm just passing that on. And my client is on the line if the court at the end has any questions. So, but essentially, Your Honor, the party shared in the care actually of 2 children. The boy Jackson was Miss Wolski's from a prior relationship, but my client treated him, just like a biological son, and then Mason, the 2-year-old, and again, both parents were essentially stay-at-home parents, although my client did work remotely. There's been some pretty severe, scurrilous allegations made against my client, the materials that Mrs. submitted, it was difficult for me to tell what was responsive to our motion and what constituted an answer to the petition. But all that aside, Your Honor, we were before Judge Warning last week on Ms. Wolski's petition for a protection order, and essentially the same information was presented to Judge Warning, and he entered a 90-day order in favor of Ms. Wolski, but refused to restrain my client from having contact with Mason. And so, as you can see from our petition and our request for temporary orders, we're asking for designation as the primary custodial parent. Ms. Wolski, we are asking that she have visitation, essentially local rule every other weekend, Friday to Sunday, and then a Wednesday night dinner night. One thing I do want to point out in her materials, Your Honor, and unfortunately they're not broken down by page number or Bates stamped, but you can see there's a page where my client is texting Miss Wolski, and she began at, I guess, October 22nd, and he sends her a text each day. When can I see my kids? They miss me. When can I see my kids? And there's basically no response from Miss Wolski. One significant factor, and I think Judge Warning kind of seized on this, there were a series of text exchanges between my client and Miss Wolski leading up to October 18th. They had celebrated an anniversary dinner at Long Beach back in September, September the 13th. The kids joined them. They went to Walmart, bought Halloween costumes, and there were photos of the kids, Mr. Torres and Miss Wolski at the apartment that my client had arranged for Miss Wolski to have. So the text messages in the run up to the 18th were certainly indicative of two parents co-parenting who had a good, working relationship. As a matter of fact, in July of this year, they took essentially a 30-day road trip to visit his relatives in Texas. And one of the things I told Judge Warning, the difficulty in the case was reconciling these texts with the allegations that Ms. Wolski has been making. But in any event, the last text sent by my client on October 18th was around 2:13 p.m., basically arranging for dinner that night. They were going to get together and go have pizza. I think that's what the plan was. Ms. Wolski was served later that afternoon at 3:00. And then the next day, up pops this protection order, and then complete blackout of communication with my client. And my client has not seen his child since then. And even before then, as you can see from the texts, his contact was severely limited without any real explanation by Ms. Wolski. So it's unfortunate that the protection order strategy was used the way it was used, and I'm sure the court's seen it a million times. It definitely was a strategic play by Ms. Wolski, completely unsubstantiated. So our position is, this information, all of this texting, it's all self-serving. None of it is supportive of the allegations that she's making. My client has been stably employed, has risen to the ranks of supervisor with the state. He's certainly doing the best he can to support his family, but he would like to have contact with his child. And we believe designating him as the primary custodial parent is the proper thing to do, given the judgment that's been exercised by Ms. Wolski. So our request for today is that he be designated the custodial. Ms. Wolski receive local rule visitation. I did note in her materials that she evidently, I think, is working 2 jobs, although I didn't see a financial declaration or any type of financial analysis. So I don't know that we can really move forward today on the issue of child support, but that's our request for today. Thank you, Your Honor.
All right. Thank you, Mr. Foley. All right, Ms. Wolski.
Yes, I have a few things I want to address about this apartment Luciano has claimed to co-sign for me, and this beach restaurant date that he is claiming None of those things are accurate. I met up with him on the 13th of October, which happened to be our anniversary, but it was not an anniversary date. I did not want him driving with the children, and things were not moving along with legal aid or anything that I was trying to get done on my end for court. And I offered to do a one-time co-parenting meeting, and he asked where, and I said at a Mexican restaurant in Long Beach, and we drove there separately. This was an hour-long occasion, and I asked for no photos to be taken of me, and next thing I know, in the mail, I have photos being delivered of me at the restaurant. We barely spoke 2 words. He's claiming that it was this lovely date, but it was literally, here's the kids, we're going to sit and monitor while we hang out. And then we let them walk up to the beach for 15 minutes, and they walk up to the rocks, and I have a photo. He took a photo of me walking up to the rocks, but we weren't communicative. It was just for him to say hi to the kids, eat a dinner, and we went separate ways. The next day, I had a falling out with one of my friends that we were staying at. And this whole time, Luciano was trying to get me to go back to the home and move back in. And I did not want to do that. I was fine having communication. He was still trying to power and control every narrative, every day of my life, even though I was away from him. I still felt controlled that I had to go see him. I contacted the police on him September 4th at my mother's residence because he stalked my phone and found me. He has a other claim, which is perfectly fine, but I don't know how else you would find me if you weren't stalking my location. He was not in contact with the kids from September 4th to September 13th. Him and I were having minimal communication, but I was just trying to figure out my new life without him. He was pressing me to go to court. He was pressing me to do all these things, and I was going on the timeline and trying to get a new job and move into a place and all of these things all at once, as well as leaving an abusive relationship. That is a lot. His control was very much just hurry up and come home to me. Just be with me. What can I do to make you be with me? He was helping when he met me on the 13th. He was very much about the kids for the first time. I left Luciano Torres because he was not a good hands-on father. He did not get out of bed. He did not help me. He did not. He worked all day long and had a beer in his hand when he was awake. He would leave for excessive amounts at the night, driving and speeding and getting pulled over. I had no help. And on top of that, I was a sex slave. So I'm being physically abused at night and whenever throughout the day that he wants. I had to be accessible to him all day. And on top of being a mom, I had no help. I couldn't do it anymore. I walked out. I was doing it alone. And when I met up with him, it was, oh, the kids, let me see the kids. I want to be with the kids. Let me help you get the kids in the car, and things he'd never done before for me, things he never helped out before. So I was like, oh my God, you're helping me. This is wonderful. But when we would go home, it was texts about, when are you coming back to me? And those are texts that he didn't want to submit. But you look so nice in those jeans, compliments I've been waiting to hear for 4 years, things I've been begging for 4 years. It was once I left and he knew I was going to court, it was just power and control constantly. I was constantly going through it. I couldn't get up and go to work because he's bullying me in the morning, first thing. But backtracking to the 14th, I'm so sorry. On the 14th, we were having a falling out with my friend's house, and he offered to get us a hotel room for the evening. And he paid for that online, and we went to the hotel, and he was not staying the evening. He helped keep the kids for a few moments so I could run up to the other house where our things were with my friend. And he left when I came back. We went earlier that day to go to the Halloween store to get the kids their Halloween costumes. He offered to purchase them. He was very much offering to help with everything that he normally wouldn't have. But again, he was, well, I want the addresses to all the apartments you're applying for. I want to know what you're doing every given day. I want to know where you are. It was still so much abuse happening mentally on my end. And I just was like, why did I even leave you? I left for a reason, because I don't want to deal with your control. wasn't being sexually abused anymore, but I'm still noticing abuse every time we spoke. And his shift of I'm this best dad once court got involved is mind-blowing to me, because those are things I begged for him to do for 4 years, even with my son, that he claims that he has this wonderful relationship with. All Luciano Torres was just offering financial help to the kids, but mom has everything else covered. He doesn't need to ask about their day because mom's got it covered. So coming from not having any ounce of support from him, and then now I'm this hands-on dad. Let's go to the Children's Museum. I'll take you to Walmart. He never went into a store with us. So now all of these big changes were happening, and it was nice. It was lovely, but I'm still going home and dealing with mental abuse, emotional abuse from him, power control, that you must do it my way. Once court's involved, I don't need to talk to you. I'm done with you. I don't have to deal with this. And I'm being told that I got this protection order to retaliate, but I was on the police getting told to get a protection order. And I'm like, I don't know what to do. I don't know what I'm doing. So as far as me and him having this dating thing, him getting an apartment for us, none of those things are true. I've done all of this on my own. I only have one job. I did get a second job because my first job wasn't giving me enough hours, but I am now full-time with that job.
On that point, Ms. Wolski?
Yes?
On your job, tell me, do you know what your hourly wage is?
I make $19.51 an hour, and right now I'm up to 36 hours a week.
And how long have you been at that job?
Since September 9th-ish.
Okay. And is there sometimes jobs will have kind of a probationary period, and then after you've completed that probationary period, then the pay increases a certain amount? Is that your situation?
I think so. I do have a training coming up in December, and I believe I may be bumped up to $20 an hour after the trainings are completed.
Okay. Thanks. Appreciate that. Go ahead.
So then once the courts got involved, I did go no contact, and I was advised to have the kids were with me. I do not want him driving, and I did not want him driving in the vehicle. And this 30-day road trip that we're talking about constantly, we were fighting really, really bad up to this point. And because I just couldn't do this sex slave job anymore. And I wanted to go get a real job. That was the big complaint all 4 years, is me constantly wanting to work, but I had to be available to him all day and to the kids because he wasn't available to them all day. So he offered to start giving me a monthly allowance, which I do have every single Venmo receipt from 2019 to 2023 that I will be submitting, as well as a evidence from this sex slave stuff. I just had to find out which way the best way to submit that is, because there's a lot of things on it that I didn't want seen by everybody. This 30-day road trip, he was taking Mason without me. He said, she's going, and I, knowing what I know about his daily to-day care of her, I would never have let her go that long without her mama, with that man.
Does he have any other children?
He does. He has a 20-year-old.
Okay.
A 20-year-old. And that child was with us on this trip.
Okay.
And Luciano drank the entire trip. I'm sorry, Your Honor.
I was just going to just ask you one quick question about Corby Johns and your mother. Can you tell me just a little bit about that issue was raised?
Yeah, Corby Johns is my sister's fiance, my brother-in-law. And he was in our life pretty much over at our house every month. Even in August we were together. So Luciano has claims about him being unsafe, but he was in our house every month for get-togethers, for occasions, for everything. And him and Luciano had a really good friendship. Honestly, they would drink and smoke together and hang out. The whole time he was in our house, they would stay the night. And then my mom, was that the other person?
Yes.
Kelly Weishar, she's my mom. Yeah, she's my support right now. I'm not sure what else you want me to say about her right now.
Okay. And then there was concerns raised regarding marijuana use. Can you address that?
Yeah, Luciano did get me dependent on marijuana 4 years ago. I was not a smoker until I had met him, and my sex slave job was getting to be where I couldn't mentally do it. And he smoked behind my back. And once I found out that he did it, he was more open about doing it. And he also told me to smoke with him. And he would start off giving me joints and like flower marijuana. And then we slowly started doing it more like medicinally, I guess, together. He claims that he has a bad back, but he went to get a medical card in order to go get his kid from foster care 4 years ago. And we smoked together. I mean, it was an everyday together thing. And I was dependent on it due to this job that he's had me do.
Does that dependence continue to today?
Occasionally, yes, but I have cut it down. I am speaking to someone on the 25th to try to get some help with my anxiety, because that is the main reason right now. But it's not been where I'm purchasing anything or I've definitely not been partaking.
Can I circle back to your job? You said you're in 1951 an hour and you're up to 36 hours a week. If at a 36-hour a week, do you know what your gross and net is?
I'm not sure right now. I'm not currently making the 36 hours because me and both children are in therapies, and I am in a few parenting classes as well that do take some of the time during the week. So technically 36 hours is what I do have in place, but it is realistically only about like 33, 34 hours a week due to all of our appointments.
Okay. All right,
and I do have the ADP app. I am trying to get logged on to that with my job, so I can print out the pay stubs for you. I have I think a 3 or 4.
Okay, thanks. All right, I think I have a pretty good idea of where you're coming from and what your position is. Do you have anything else you want to share before I turn the time to Mr. Foley?
So with his driving, that was the big reason why I stayed in contact with him over the month. I did want him to see his child. I did not ever want I wanted him to make some changes, honestly. That's what I would ask, is that changes are made. Because he did get pulled over twice with us in the car, and that was just the 2 times he did get caught within this last year. I did submit plenty of times of him driving and speeding with us in the vehicle, but I do have the police reports from those evenings stating that we were in the car, and when he was asked why he was driving those speeds with children and vulnerable people in the car, he didn't answer. But continues to do it anyway. My concern is that when I was in the car, okay, there's at least another adult, but what happens when there's no other adult in the picture and he's still doing these things? So the driving is my biggest concern. And now that I have no contact with him, I do feel a little bit better about this going forward of him hopefully being able to make changes in order to have her more than what I did offer that's just what I'm willing to negotiate on right now, because of all the things that I do know that he does do on a normal basis. He has only had her one overnight in her entire existence, and that was July 31st of 2021. And other than that, she has been in 100% my care. Everything she has was gotten by me. And that is also another question I do have about all of our belongings that are still in his home. We left with just the clothes on our back, and we have gotten to go back a couple of times in September to retrieve a couple of things. But I mean, I'm talking about the kids' toys that I've put in the house. I have pictures and documents that I haven't been able to get. I didn't expect to not be able to just get everything out after moving, but with the way that it is, a protection order did have to happen with our communication.
Okay.
And then I'm sorry, Your Honor, I do have a vehicle in my name that is also in Luciano's name, and it's broken down right now. My dad is trying to work on it, and so I can sell it. It is a Range Rover, and I'm trying to figure out what I need to do about that to get his name taken off. We both put half for the vehicle. We both paid half for the vehicle. I put the down payment. He paid the rest. It was a $10,000 vehicle. I do have the title with me, but the vehicle is not drivable right now, and I am borrowing a vehicle from a family. So I'm just trying to figure out what I need to do for that as well.
All right, thank you, Ms. Wolski. Mr. Foley?
Thank you, Your Honor. I refrain from objecting because there's obviously a lot of material that she mentioned that wasn't contained in any of the written materials that she submitted. But the reason for that, Your Honor, I think, is to make a point to you that obviously the protection order, for whatever reason, was a strategic filing. She was not afraid of him, as she indicated in her petition to the court. As you heard her testify, she continued to meet up with him, to go back, to go to his house. I mean, obviously there was no fear of my client. So that's unfortunate, but it's where we find ourselves today. Going back to the issue of judgment that I'd indicated, and I think particularly the way she framed her reference to the protection order, she wanted things to change in terms of a relationship with him. And she felt, okay, if he did these things, then in terms of their relationship, it would be okay for him to have more time with his daughter. Unfortunately, that's not the standard. The standard is what is in the best interest of the child, not what is in the best interest of mother and her relationship with father. And so, again, I think it shows the lack of judgment on Miss Wolski's part, because she's indicating to the court that, yeah, she's good with him having more time, and yet she's withheld the child without any explanation from my client since, at least October 18th, when she was served with the papers. The other piece that I think needs to be mentioned, and I mentioned it to Judge Warning, which is why I think he limited this order to 90 days. There's no evidence to support, and there's been reference to this, sex slave stuff. There's no evidence supporting that. There's no declaration from family members, from friends, from coworkers, or whoever. There's no CPS reports, no founded findings, not even an investigation. There's no police reports that you would normally see in a situation like this. And then she refers to his control over her in photos, and she ran this by Judge Warning, and there were no photos to support any of the allegations. The issue is my client holds a senior position with the state of Washington, and if he laid around all day drinking whiskey and drinking beer, he wouldn't be working two jobs, number one. Number two, he wouldn't be progressing up the ranks with the state of Washington or any other employer for that matter. So again, I think it's challenging for the court. It was challenging, I think, for Judge Warning, but to reconcile these types of allegations with the objective evidence that the court has before it. So again, we're asking for my client to be designated the primary custodial, for mother to have alternating weekend visitation, and a carve out. And I think this is kind of what Judge Warning was suggesting that your role, or the commissioner's role, would be in this case, is to carve out something that accepts the protection order for communication between the parents for purposes of arranging visitation, purposes of anything having to do with the children. Everything else, I understand the order will remain in place, but there does have to be a carve out for that type of contact. So that's our request for this morning. This business about driving, that's just the last point I'll make. My client has a valid license, proof of insurance. Again, I don't, from looking at the materials, there's photos of her in the car, but again, I can't make heads or tails of what any of that means. So thank you, Your Honor.
Okay, thank you. Ms. Wolski, I'll give you just a few moments. So I'll just give you a few moments, so go ahead.
There is a CPS investigation going on. I have been investigated already, and I was told that his investigation is still ongoing due to the negligence of Mason Torres.
Now I am going to object, Your Honor, to hearsay.
Sustained. So Ms. Wolski, the objection is sustained. That means that it's not contained in any documents, and it's
Mhm.
a statement from somebody who's out of court that we can't examine and talk
Yeah.
to. So you won't be able to discuss that particular
Yeah,
one.
okay. And then I do have my contract here that Luciano Torres and I had that I will be submitting to the court. This is the one that I was trying to figure out if I could seal and which route to go. And this will be mailed to you, Mr. Foley, as well.
Same objection, Your Honor. She's testifying to a document that hasn't been submitted. I haven't seen it. I have no way to address it.
Yeah, the objections noted. I think she's just stating that she's going to be submitting it.
Yeah, there is more evidence to be submitted. I was just trying to figure out how to have that sealed, as there are explicit photos and comments and conversation on there that I just didn't want open to everybody to see. But I don't think I was able to have that sealed. I was called this morning whenever I filed that. They called me back this morning saying that I couldn't have it. So I am trying to still figure that out. Yeah, we do have open cases there. I do have the traffic police reports from his tickets, and then I am still trying to obtain the police report from the night I called the police when they came to my mom's address on September 4th. So I am in the works of getting all of that still, and we'll submit those.
All right, thank you. All right, so we're here this morning on Mr. Torres's motion for temporary orders. As far as child support, there's a request for child support. I think I have a fairly clear idea of at least one of Mr. Torres's jobs. The other one, I don't have a very clear idea of what amount he's earning. And I think I'm kind of in an equal position with regard to Ms. Wolski's earnings. We have a general idea, but I think the precise numbers are somewhat they're not present. So I'm going to reserve on the issue of child support until we have further information about Ms. Wolski. There's something called a family financial declaration, and then pay stubs. That information is very helpful in making a determination. And then Mr. Torres will submit additional information related to the SSI company. So that issue is reserved. So the main issue before the court today is the parenting plan, and both parties alluded to this. The court's focus is the best interest of the child, Mason. And that's what we look at. And there's a lot of different factors that go into this. And so taking a look at the evidence that was presented to the court today, it sounds like Mr. Torres is a good wage earner, has a good job. I assume he works hard at his job. Ms. Wolski, during their time together, didn't really work outside of the home. I guess that was an agreement or an expressed preference between the parties. And that so what we know is that during that time frame, the way it looks to me is that Ms. Wolski tended to be the primary caregiver to the child, and Mr. Torres, while working at home, did have some interaction, but during the workday he was pretty focused on his work. And I think the evidence shows that Ms. Wolski tended to be the primary caregiver of the child. And so I'm going to designate her as the primary parent in the parenting plan. I know that there's concerns related to maybe a lack of overnights that the child has spent with Mr. Torres. Does have an older child, so he does have parenting experience. He's not the first rodeo, if you will. So I'm gonna designate his residential time to be on alternating weekends, first, third, and fifth weekends of the month, as designated by a Friday at 5 p.m. until Sunday at 5 p.m. And also every midweek visit from 5 to 8 p.m. Now, with the protection order that's in place, it becomes a little tricky as far as exchanges. So the parent whose time will begin with the child, so that could be at the beginning of a residential time or the end of residential time. So the parent whose time is starting, they'll need to arrange for someone to pick up the child, meaning with the protection order, Mr. Torres will have to have a third party be the person that does the exchange, because he can't be there in proximity with Ms. Wolski. And then when Ms. Wolski picks up the child to start her residential time, Mr. Torres will have to have a third party there presenting the child. So, and I'm not sure if the parties have discussed an exchange location or not.
Your Honor, I was going to bring that up. I'm assuming Miss Wolski is living north in Rochester with her mother. Is that correct? Or are you back in Longview, Kelso?
I have an apartment in Kelso that I reside in with the children.
Okay, great.
And then go ahead.
Well, I was going to say, where would be a convenient pickup and drop off?
Hall of Justice. Is that Hall of Justice?
The Hall of Justice in Kelso.
Okay.
Oh,
Your Honor, I mean, I know how those things work. I mean, the building itself offers no protection. So maybe what we can do is the sheriff's office, which is across the street.
So when you say across the street, sheriff's office, across the street, because the Hall of Justice houses the sheriff's department.
Oh, okay. All right. Yeah, I just wasn't sure if she was referring to the courthouse specifically. So
Yeah,
that's fine.
So
That'll be.
Yeah, okay, so we'll do that. We'll do the exchange location will be the Hall of Justice, courts, the prosecutor's office, and the sheriff's office also. That'll be the exchange location. As far as I'm going to restrict marijuana use during the residential time with the child unless it's prescribed by a physician at a particular increments, which I don't think I've ever seen a prescription for marijuana that says take it 3 times daily or once at night. I've never seen that. But if it is, then that would be allowed. But otherwise, the marijuana is prevented or prohibited from being ingested during the time with the child. I'm also going to, pardon me, impose a restriction on both parties. Basically, it's a requirement that they obey all traffic rules while driving with the children. I think that's important. That will address that concern, hopefully. With regard to the belongings that Ms. Wolski mentioned are still in the home, I think that's maybe something you could speak to Mr. Foley and work on particulars on that. You know, sometimes if the negotiations break down, then you can bring a motion to the court to address those particular belongings. But usually the parties can work that out.
And Your Honor, if I could just interject on that. So,
Yeah.
Ms. Wolski, if you want to make a list of the items that you would like to have, go ahead and do that and send it to me, and then I can forward it on to Luciano. And then to the extent you guys agree, we can make arrangements. If there's disagreement, then as Judge said, we would take it back to the court.
with her being in his care, I do want to make sure that she has things already there. I have provided most things for my new home for her, but I do want to split up some of her toys and stuff and some of the stuff that's left behind. That way he'll have a bed for her and toys when he has her.
And Your Honor, I wasn't sure if you were finished. I don't want to interrupt the court, but I do have a question on starting visitation.
Yes. Let me finish up and then remind
Okay.
the issue. Excuse me. The issue with Corby Johns, I'm just going to enter a kind of a cautionary protection that Corby Johns not be left alone or unattended with the child. So there'll always need to be somebody, another adult in the presence of the child if Corby Johns is present. So,
Yeah, and I already have taken that into play as well during this time.
Okay, great. And then as far as the beginning time for the visitation, so the first weekend is the 3rd. The 3rd weekend is the 17th. The 4th or the 1, 2, 3, 4, 5th weekend would be, well, the 1st and 5th is the same. So December 1st. So we're looking at a December 1st start time.
And so my request, Your Honor, would be for November only.
Mhm.
If we could have this weekend, because as I indicated, my client hasn't seen his child in, quite some time.
Mhm.
So one thought would be for the month of November, we could have visitation beginning Friday, the 24th at 5 p.m., ending Sunday, the 26th at 5 p.m. Then mother would have the remainder of that week. And then father would have the 1st and the 2nd, and then we'd be back on the 1st, 3rd, and 5th. I realize it's 2 weekends. Technically, it's 2 weekends in a row, but I think given the circumstances, it's an appropriate request.
Okay. So I think, there's concerns related that the father hasn't seen the child for a period of time. It's alleged to be from October 18th. So I want to just kind of ease into this a little bit. So it'll be Saturday, the 25th at 5 p.m. until Sunday, the 26th at 5 p.m. for the first visit. And then we'll kick into the 1st, 3rd, and the 5th, which will begin in December.
Okay. Thank you, Your Honor.
So let me ask, that's the court's ruling. So let me just ask if the parties have any questions or clarifications. Mr. Foley, Ms. Wolski?
I don't have any more questions.
I don't think so, Your Honor. Can I just ask if my client could go on screen, and I just want to make sure it's clear with him. So Luciano, can you turn your camera on? Well, as long as I got you audio, do you have any questions about the court's ruling?
Not at this time, no.
Okay. All right, Your Honor. I think that takes care of it.
So let's talk just briefly about a date for a presentation. So this is a motion brought by Mr. Torres. attorney, Mr. Foley. So he would be expected to prepare the parenting plan. So we'll take a look at a Tuesday in which we could set that for a presentation. So what that is, Ms. Wolski, is that the court made some orders related to the parenting plan, and then Mr. Foley will document those or summarize those in a document, the parenting plan, and then he would submit that to you for your review, and it's submitted to the court for its review. And then if you have any objections, you could note those objections by filing objections and say, hey, the court didn't order this. This is actually what the court ordered, or you feel that the particular language is better with your version. You could submit that. And then we'd come back on a particular day for that presentation. If you agree with what Mr. Foley drafts and he says, oh yeah, that's accurate, that's what the judge ordered, then you could simply sign off on it and then return it to the court, and then I would sign it. However, if you have any objections or concerns about it, then we'd look at a date for a presentation in which both parties can argue their points. So we're probably looking at a minimum of 2 weeks. So the earliest would probably be on December 5th. And I'll just ask the parties if the 5th works for each.
Yes, Your Honor, that works for me.
Yes.
Yes, Your Honor.
Okay, great. So we'll look at December 5th. We will set it for that date, December 5th at 9 a.m. for the presentation. Mr. Foley will get those orders out to you, Ms. Wolski, and then if you have any objections, file those objections with the court and send Mr. Foley a copy of the objections.
And then, Ms. Wolski, I will need an address, or well, let me ask. I'll need an email address and a street address.
I have received something in the mail from you at my current address.
Okay. So we'll
Yeah.
just use that one then.
Yeah.
Okay. And then, Your Honor, I did have a question on the protection order, because this order from the court, Ms. Wolski, is effective today, even though we don't have written documentation of it. So I realize there's a protection order. I think we get around that by the third party. But how do you want me to handle is the court entertaining a carve out at all for communication regarding the children?
I am. I think that's important. If there's ever to be some type of an emergency related to the well-being of the child, the parties need to communicate regarding that.
I do agree with that, but I would like it to just be where it is only about Mason, not about Jackson or just Mason.
Yeah, I am creating a carve out. I think that's appropriate, that the communication would be allowed in contravention to the protection order for solely related to the emergent or emergency needs of the child. So I think that covers it. I think there's a lot of things that, could go through maybe a third party to share information, like I'm running late, that could go to the third party. That's not an emergency. But if there's any type of emergency, then they would be allowed to communicate.
Great.
Thank you for that clarification, Mr. Foley.
Thank you, Your Honor. All right. Thank you very much.
All right. So if there's no further questions, we will see everybody on December 5th at 9 a.m. for the presentation.